Mr. Murali.
Mr. Deputy Speaker, sir, I first declare my interest as a practicing lawyer who occasionally handles criminal cases, including drug cases. Singapore has always taken a hard stance on drugs. Honourable members who spoke before me support this stance. This is a reflection of our understanding of the pernicious effects that drugs and drug addiction has on our communities and the need to ensure that drug consumption does not become an entrenched habit in our society. There's also a recognition in recent years that whilst it remains necessary to ensure that our laws deter drug trafficking, possession and consumption, there's also a need for a broader range of measures to rehabilitate offenders to mitigate the risk of relapse. The proposed amendments to the Act serves these two purposes, enhancing our enforcement powers against drug-related activities, especially where young children are concerned, and at the same time strengthening the drug rehabilitation regime by taking a more calibrated approach vis-à-vis drug abusers. I support the aims of the bill. I have a few queries. First, the bill proposes a new Section 33, subsection 3A, which prescribes a mandatory minimum sentence of 1 year for first-time offenders of a Section 8 offence of drug possession or consumption. This represents quite a shift from the status quo currently, where there is no prescribed minimum sentence, and therefore a court is entitled to impose a sentence of a fine and or a jail of less than 1 year. The present sentencing norm for first-time drug consumption is about between 6 to 8 months imprisonment. Taking into account remission, the length of imprisonment is approximately between 4 to 5 months. At the same time, the present regime also contemplates rehabilitation in the Drug Rehabilitation Center, DRC, for first-time offenders with no criminal record. This is generally a term of approximately 8 months. I understand that the proposed amendments would address the existing disparity, namely that a first-time offender who is unsuitable for DRC, for example, if he had committed other offences together with a drug consumption offence, and is sentenced to imprisonment, he would serve a shorter term than a first-time offender who is deemed suitable and sentenced to undergo treatment at a DRC. If the focus is to address this disparity, why not put this before the court rather than impose a mandatory minimum sentence? The court will then have a discretion in sentencing to impose a sentence that suits the circumstances of the case. For example, drawing a distinction in sentencing between the consumption of a Class A drug, which is more serious, versus a Class C drug. After all, the sentence should take into account the circumstances of each individual offender to distinguish between their differing degrees of criminal culpability. The existing provisions allow the courts this flexibility. This is encapsulated by a High Court decision where the court said, adopting this wider spectrum of sentencing options for first-time offenders will allow adequate regard to be duly given to the many imponderables involved when such offences are committed, such as what was the amount of drugs consumed? What was the occasion that led to the act of consumption? Was it planned or incidental to some other event? Was any money involved? Is the accused a first-time drug consumer, a casual consumer, or an addict? While this by no means is a comprehensive or exhaustive list, it is intended to highlight some of the thought processes a sentencing judge should apply when determining the appropriate custodial sentence for drug consumption offences. Given that not all offences of consumption are the same, it follows that not all acts of consumption ought to be punished identically with a rigid, immutable starting point that constitutes an end by itself, unquote. This is not to say that the courts would treat drug possession or drug consumption lightly. In the same case, the court actually expressly recognized that fine may be imposed in very limited circumstances when young offender with no antecedents is involved. And even then, it cannot be invariable practice for such offenders. Additionally, there need not be parity between a DRC regime and imprisonment in terms of the length of time, given both regimes serve different purposes. We are not necessarily comparing apples with apples. A DRC incarceration is not a conviction, and the primary purpose of DRC is to rehabilitate, which understandably requires some time. In contrast, a person dealt with the courts, convicted and sentenced, will have a conviction record. And the aims of imprisonment is more retributive and does not necessarily involve a pure focus on rehabilitation. My concern is that there could be situations where it does not make sense for a person to be sentenced to a DRC and yet may not necessarily make sense for the person to be sentenced to a 1-year imprisonment term. For example, a foreign national who commits a drug offense in Singapore while on a social visit pass. There's little utility in sending him to DRC for rehabilitation, given that he's not a resident in Singapore. But with the amendments, the court will now have no choice but to sentence him to an imprisonment for at least 1 year, even if the offense may be on the relatively less culpable side. May I please ask, what's the policy consideration for the decision to impose a minimum mandatory sentence for drug consumption and possession, regardless of the circumstances, and remove the judicial discretion in this regard? I now move to Section 34. Section 34 deals with the increase of the maximum duration of supervision from 2 years to 5 years. I understand from the Honourable Minister's speech that this is because the focus is on making sure that the drug addict is fully rehabilitated and the chances of recidivism is reduced. I support this aim, and as I understand, if a drug addict beyond a 5-year mark does not take drugs, then the chances are he would not take drugs in the future. And this would be a good objective to realize, because families fractured by members who take drugs can then have a chance to be wholly reunited again. I note that the explanatory note suggests that there's no increase in public expenditure to this bill. However, I would imagine that there would be resourcing and staffing issues, given that the contemplated extension of period of supervision is for a period of up to 5 years. May I please ask, what are the plans that the Minister has in this area? Before I sit, Mr. Deputy Speaker, sir, I would like to pay tribute to the good work of the CNB officers over the years since CNB was established in 1971. We had a serious problem with drugs then. This is a stark memory for me, because as a young boy, I grew up in a neighborhood where I played football almost every day with some very talented footballers who could perform mesmerizing tricks. They could have made it into the national squad. In fact, some of my team did, but they could not make it into the national squad because they became addicted to drugs, and their whole lives were wasted. It was the government's and the CNB's tough and uncompromising stance against drugs that allowed us to emerge from that dark situation to now enjoy a relatively drug-free and low-crime environment. I highlight low crime because there's always been a link between drug taking and crime. Many drug addicts resort to crime to be able to fund their habit. There's also a positive economic impact arising from the successful tackling of the drug problem. We managed to ensure that the people who would otherwise be snared by the lure of drugs would be economically active and contribute to their families and our country. In contrast, a good number of countries have gone the opposite way. I had occasion to listen to the speech of Ms. Bridget Brennan, the Special Prosecutor for Narcotics in the city of New York, USA, last year at the Economic Crime Symposium in Cambridge, UK. She reported that in the US, life expectancy has gone down for 3 consecutive years, and she attributed it to the serious drug problem her country has. She also opined that opiate addiction has led to less economic participation amongst her people. The situation has been exacerbated by the advent of synthetic drugs such as fentanyl, which is very addictive and only a fifth of the cost of heroin. I highlight this not to gloat, but really to join in the suggestion that the Honourable Member of the honourable member, Mr. Christopher D'Souza, made in terms of highlighting these cases to people who may otherwise take a softer stance to drugs. Given our geographical proximity to the centers of production of controlled drugs, higher levels of drug production, as the Honourable Minister said, as well as our status as an international transport hub, we could easily be in the same situation as in the US if not for our dedicated and courageous officers working in tandem with other government agencies, but critically with the wholehearted support of Singaporeans. The job that our CNB officers do on a day-to-day basis is clearly not for the faint-hearted, as the people they deal with, especially the drug traffickers, tend to be more desperate and violent given the stakes should they get apprehended. We owe them a debt of gratitude. Thank you.